And as expected, there is politics over the Karnataka High Court order on hijab. PDP Chief Mehbooba Mufti calls the order disappointing. She further says that women are being denied their right to choice. That's the word coming in. Mufti Isla is with us on the broadcast. Mufti, the word coming in from Mehbooba Mufti on expected lines, I would say.
Well, yes, and she's been extremely critical of the move since this controversy broke out. When the girls were barred to attend education. That happened in Karnataka a few months back. And clearly then the case went to the court. And now court has educated that whatever school decides, that's going to happen. Clearly Mehbooba Mufti is peeved because she had maintained a stand that women should be given a choice. And she has hit out at the government saying that rather she's disappointed with the verdict today. She's saying that on one hand, we talk about empowering women, yet they're being denied the right to simple choice. It isn't just about religion, but freedom to exhibit choice. So clearly she is hitting at it. And in fact, this was the initial reaction when this controversy was going on. She did mention that this should not have happened and girls should be allowed a choice, whether they want to sit in examination or attend to education. That's up to them. They want to do it in a hijab or without hijab. So clearly this is the first political pushback from Jammu and Kashmir.
First pushback, and expect more reactions on these lines to come in, as this judgment is also going to invoke a lot of political reactions. There has been a lot of political controversy as well on this entire issue. You had the chief opposition party, the Congress party in the state of Karnataka, issuing a statement saying that women have a right to wear hijab in school premises if they want to. Well, the Karnataka High Court clearly disagrees. I'm going back to my guests, Ms. Zakia Soman and Prateek Som, who's a lawyer, continue to be with us on the broadcast. Prateek, what is the lens with which we should view this judgment? Yes, a written order copy is awaited, and the reasoning is going to be very, very critical. But is this more about religious reform, or the state institutions rather drawing a terse line, a very clear line of the secular nature of the institutions?
See, first of all, lens of religion bias has to be removed at this. We have to understand this government order does not only restrict the wearing of hijab, but also restricts wearing of saffron scarf. So now the High Court decided that whether, Article 25, that is freedom of religion in India, which guarantees freedom of religion to all persons in India, it also provides that persons in India are subject to public order, morality, health and other provisions. So High Court has decided on that. They have decided that school is not a place where you can propagate religion. It is a secular place, and it says that it under Article 25, wearing of hijab is not ERP. It's not an essential religion of practice. So a clear distinction has come from High Court that freedom of religion, which is guaranteed under Article 25, is not violated through this order, which restricts wearing of hijab and also wearing of saffron scarves. So it says that school is a secular place. You cannot propagate religion bias there, and therefore they have upheld this particular
but
order
Prateek,
of the
taking this debate forward, and yes, the Karnataka Honorable Court has set this order very, very clearly, that the Karnataka government had the order and the rights to pass the orders that they did. Hijab is not covered under ERP, Essential Religious Practice Test, that has been prescribed by the Supreme Court in various cases. The latest reiteration was in the Sabrimala case by a constitution bench of 5 judges. But is it so black and white? The secularism in our state-run institutions is of a very fluid nature. There are various expressions of cultural identity which are expected in our ethos and democratic conventions. Do you think a country like India can draw a very strict line like a country like US that has not been a convention or culture, constitutionally speaking?
See, constitutional recognizes freedom of religion. That is very well established under Article 25. But there are some bifurcations which is to be done, and this is the recent example where High Court has given its judicial mind that whether a particular practice is part of religion or not. And it categorically says that essential religion of practice do not include wearing of hijab or either wearing of saffron scarf, where at the place which is deemed secular, which is deemed to be non-religious, and that is the school. So this is the particular point on which High Court has applied its judicial mind. Of course, the matter, when it will go to the Supreme Court, may refer it to the Constitution bench, because Sabrimala judgment has to be reviewed in this particular matter, and thereafter, the honorable bench will decide whether it violates Article 25 or not.
You're right in pointing that out, that this is likely to go to the Supreme Court. Zakia, I'm coming back to you. And I want an internal perspective of how the community, the Muslim community, sees a decision like this. You have certain girls who went to the Karnataka High Court and said, like they had a right under the Indian Constitution, that we want to wear a hijab. Please allow us to wear a hijab. The Karnataka High Court said, look, if you want to go to the school, you will have to adhere to the uniform. The state government has a right to do that, and your hijab is not covered under the essential religious practice. How is it being perceived within the community? Are there strong biases? Are there strong divisions within the community when you see a decision like this coming in from the High Court?
So when we say the community, we have to make a distinction between ordinary people and people who are, religious bodies or quasi-religious political bodies.
For sure.
So as far as, my work and my experience suggests, average people, average Muslims all over the country are ready for change. They are ready for reform. The way, we saw even in the movement against triple talaq, we received support from all quarters of the country. We received support across all states, across all geographies. But the resistance comes from certain vested groups who are, like the Personal Law Board. And now in this case, it is, another group there in Karnataka. So the thing is that it's very important, I was listening to what you were discussing with the fellow panelists.
Yeah.
It's very important that the demand for reform and the will to reform comes within the community. And I think the community is ready for reform. But it is these kind of, powerful religious bodies supported by political bodies who are the ones who are, posing barriers to the, whole process of reform. And I think it's now more than 70 years to India's independence. So it's high time that the minority citizens, the Muslim citizens, are also brought at par in all legal matters. And our secularism is not the French kind of a secularism.
Yes.
It is a very, Indian kind of a secularism, because our constitution also gives right to religious freedom. And at the same time upholds the secularism, it upholds the diversity and pluralism.
Yes.
So this kind of an issue, I feel it has been blown out of proportion.
Yeah.
And it should have been sorted out locally right at the very beginning. And there shouldn't have been need to go to the court and things like that.
Well, a lot of people, Zakia, would agree with you,
mishandled.
because it was being said that there were certain elements or political outfits who were very interested to blow up this debate beyond proportion. That is why we saw law and order situation also emerging out in the state and prohibitory orders being imposed today. Let's tell you some more about what the High Court has said. For the viewers who have just joined us, it's a big order coming in from the Karnataka High Court. Hijab has been established as a non-essential practice, which means